Cross and welcome to Cross-Examination. I'm a barrister in London working on cases with cultural, moral and ethical importance. In this podcast, expert panellists join me to take an independent look at the law surrounding one of these issues. Doug Paulley has long-term illnesses, including diabetes and a heart condition, which make him particularly vulnerable to overheating. In his care home on hot days, he struggles. He hibernates with doors and curtains shut and with the benefit of air conditioning machines. Going outside is not an option. And it's not just disabled people like him who have witnessed the impact of global warming at a direct and personal level. A co-claimant in litigation being brought by Doug and Friends of the Earth, Kevin Jordan, lives in fear that his home, now just 5 metres from the cliff on the edge of coastal dunes in Norfolk, will be lost to coastal erosion. Those proceedings, brought by the solicitors Lee Day against the government's National Adaptation Programme, are just the latest in a series of attempts in the national courts demanding that the state do more to tackle climate change. Some notable recent decisions suggest that the courts in this country may be becoming more receptive to such challenges. But the extent to which a court is suitably qualified to adjudicate on some types of issue in this policy area remains controversial. And there's a question of effectiveness. If climate change respects no borders, is it not a problem which can only properly be addressed on the international plane? So, where is climate change law applicable in the UK got to, and where is it going? Cross-examining with me today are, as always, two of the most prominent and, of course, expert lawyers in the field. Sahil Kher is a senior associate at Kingsley Napley, working on a range of public law, but with particular expertise in environmental and climate change judicial reviews, having worked on some of the highest-profile recent cases before the English courts. In a previous role at a prominent non-governmental organisation, he worked closely with community groups impacted by the effects of climate change, as well as journalists and NGOs at the frontline of advocacy on climate change and environmental issues. Hi, Sahil.
Thanks, John, for having me on.
Margherita Cornaglia is a barrister specialising in climate and environmental law and litigation. Her practice spans both public law and private, domestic and transnational environmental law. She currently acts as junior counsel to Doug Paulley and others in the proceedings I mentioned in the introduction, represents a state and various NGOs in climate advisory proceedings, respectively before the International Court of Justice and the Inter-American Court of Human Rights, and still manages to find the time to work with lawyers, scientists and journalists in Italy, her home country, where she hopes to incentivise greater public and legal engagement with the climate crisis. Hi, Margherita.
Hi, it's great to be here.
And welcome to you both. Margherita, I use the expression climate change law in that introduction. I think justifiably so, not least because there is a Climate Change Act in this country, which we're going to come to. But the position is, isn't it, that the law really, as so described, is found in a number of different places, which maybe reflects that there are different levels at which the problem of the release of greenhouse gases can be tackled. And I wonder if you can perhaps think of it as, if you like, in a hierarchy, kind of international, national and local level. Help introduce the topic for us. Tell us about how what those different levels are and how they interrelate.
Of course. Thank you very much, Tom. And that's absolutely correct. Climate law is a term that perhaps has started to be used very recently. It is made up of a set of different laws, policies and principles at the international, regional and national level. And even within the national level, the term climate law really spans a number of different areas of law. So it could be public law, private law, to some extent employment law as well.
Right, so public law is people taking on the state in some capacity, a public authority, whether central government or local government, for example. And private law is, if you like, you versus me law, without involving the state. And all of that could have a bearing on climate.
Certainly. And taking a step back and starting from the international level, which you did mention, the climate process, the climate negotiation process at the international level has been going on for many years. A landmark date is certainly 1992, when the UN Framework Convention on Climate Change was adopted. That was the first large framework agreement between multiple states where commitments were made to address the climate crisis. We've moved beyond that quite a bit since then, and the next framework key agreement is the Paris Agreement, which is passed in 2015. And by that agreement, states committed to reduce greenhouse gas emissions to try to keep global temperatures below 2 degrees and to make the best efforts to keep temperatures below 1.5 degrees Celsius.
But that international level doesn't itself form part of UK law or necessarily the law of individual countries who are state signatories to.
It doesn't. There's a general understanding in international law that states can have a monist system or a dualist system, and those states that have a dualist system require domestic implementation of international treaty agreements before those treaty agreements take effect in the laws of the country. Some states, like Kenya, for instance, in Kenya's constitution, Article 2, it's stated very clearly that international law forms part of the domestic system of law. So in those circumstances, the Paris Agreement would have direct effect. In the UK's circumstances, it does not. It requires implementation. And as you said, we've had that through the Climate Change Act 2008, which was then amended to reflect the temperature target in the Paris Agreement.
Let's go to the UK then. What is the principal legislation in the UK specifically relating to climate, I guess, rather than environmental law more broadly?
So the UK was a front runner in passing climate legislation. The Climate Change Act of 2008 is one of the first such legislative measures in the world. It sets in Part 1 a binding net zero target that progressive governments are under an obligation to achieve by passing carbon budgets and ensuring that emissions reduce progressively towards a zero emission target in 2050. Part 1 of the Act addresses mitigation of climate change, so those actions that we take to try to address the causes of climate change, namely emissions. So what measures should public authorities take to reduce those emissions?
Right, so mitigation is how do you stop or prevent or slow down? But there's another element, which is adaptation.
And that is also addressed in the Climate Change Act. That's Part 4 of the Climate Change Act. In the adaptation context, obviously, by reason of the nature of adaptation, it's difficult to have a long-term quantified target, as you would in the mitigation space. In terms of mitigation, one can say, I will reach zero emissions by this date. In adaptation, that mechanism just doesn't exist by reason of the nature of adaptation. So the framework in Part 4 is slightly different. It requires the Secretary of State to report to Parliament in terms of what risks the UK is facing because of climate change. So now we're looking not at the causes of climate change, but its impacts, its consequences. And then the Secretary of State needs to publish a subsequent report explaining how the government will address those consequences, how the government will ensure that the country adapts to climate change.
So those are provisions which are holding to account the UK government, the national government, in relation to action that it is taking, and that is under the Climate Change Act 2008. I suppose there are all sorts of decisions about whether or not individual causes of emissions, in other words, development projects that give rise to emissions, should be approved or not, and that's at the more local level. So let's drill down into a couple of those areas a bit more, just focused on court challenges to national strategy or policy. There's been some level of success recently, I think it's fair to say, isn't it, for those wanting to apply pressure on the national government in this country. Our courts have they more receptive to challenges of that sort brought under the Act?
Indeed, and I think it's fair to say that some of the recent developments have come as a pleasant surprise for environmental campaigners and suggest a slight shift of judicial attitudes. And two recent cases that best illustrate this were actually brought by the same set of clients and related to essentially the government's an economy-wide plan for cutting UK's greenhouse gas emissions in light of the Climate Change Act targets that Margherita explained. The first case dealt with what was called the net zero strategy, which was published in 2021. The government set out a roadmap of how it was going to get to net zero by 2050. But crucially, within that roadmap, failed to articulate what the contribution of various individual policies was going to be to the UK reaching ultimately the target of net zero by 2050, and along the way what are known as carbon budgets, which are essentially restrictions on the total amount of greenhouse gases that the UK can emit over a 5-year period. So they're short-term targets and then sort of a long-term, long-stop target. And that was declared unlawful in 2022. It was found that the Secretary of State hadn't been properly briefed about crucial information about about individual policies and the contributions they would make. And essentially, in failing to then, as a result, report that to Parliament, had failed to meet its statutory duties under the Climate Change Act. And I think that's kind of crucial, because I think the court's reframing of issues as also being issues not just of climate policy, but also of transparency, and that the Parliament and the public have the right to know how the government intends to meet its legal targets.
But fundamentally, it was a case about the process by which the Secretary of State made the decision to set the overall policy.
That's correct. So it didn't really deal with the specific measures, although there was always a level of argument about how realistic some of the measures were.
Right.
But fundamentally, it was about process. Had the government met its statutory duties under Section 13 and 14 of the Climate Change Act to spell out how it would achieve this legally binding target? What happened as a result of that first case was that the government was given a few months to go and redo its work and produce a lawful plan. That resulted in the Carbon Budget Delivery Plan being published in March, was that 2023, I think. But following another legal challenge, again by the same group of claimants, the government was once again found to be in breach of its legal duties. And again, it became a question of process rather than substance. None of the claimants tried to argue that the measures that the government was proposing were fundamentally flawed. But in this case, in the second case, the crucial issue was whether the government had properly accounted for the risks of delivery. And I think all of this, I mean, if I was to summarise the court's sort of response in general to challenges to national level policy, I think they're learning to see the wood from the trees. The critical question in public law, when you're trying to challenge government, is often it boils down to, is the public authority doing something? And if so, that buys them a little bit of wriggle room. Courts aren't particularly keen to interfere when the government seems to be doing something in furtherance of its sort of legal obligations. But in the climate change context particularly, and I think a lot of this is quite context specific, where there are now very clear legal targets by 2050 and the carbon budgets I mentioned, which are the sort of shorter 5-year targets, the courts seem a little bit more inclined now to ask, is what you're doing good enough? And if so, show Parliament and the public you're working. And I think that's a real shift in mindsets. And you know, climate change litigation is a long-term game.
Yes.
And I think we've reached a stage now where courts understand the science a bit better and are asking more questions.
So the court may yet be slow to gainsay the answer in terms of the policy that's arrived at, but are being more willing to look at the process by which it's arrived at.
Exactly. And I think the courts have been very clear that they aren't interested in the specifics of what the government is doing necessarily in terms of policy decisions. And the government has a lot of latitude to do that. But it needs to be realistic, and it needs to be, the working needs to be shown.
What about the more local level that Margherita mentioned? In other words, planning decisions by local planning authorities to approve or not some other development. There's been a very important recent, seemed to me, development in a Supreme Court judgment on that. Just explain that.
The long-awaited Finch judgment was handed down just last month, about a year after it was heard by the Supreme Court, which is a fairly long period of time. And the background to that was, as you said, a local decision, fundamentally a local decision. And I think one of the interesting things about climate change litigation, it operates at various levels, as you said, but a lot of development of the law and the sort of practically how decisions that have an impact on the UK meeting its greenhouse gas targets actually play out at a local level. So this case started before Surrey County Council. A developer sought some planning permission to retain and expand an onshore oil well. Yep. There were 2 wells and they wanted to drill 4 additional ones. They produce, as they're required to under law, an environmental statement. And the environmental statement said, we think the environmental impact of this development is X and Y, and that focus purely on the production process and the work on the site itself. So
yes.
all very localised.
So doing the actual development for which the application was made, what are the environmental limits of doing that?
On that
itself?
side.
That's all they looked at when they appraised it.
Indeed. So on that side, within those boundaries, what it didn't consider is what are now known as downstream emissions, which is hang on, that the greenhouse gas emissions that will arise when the oil that is extracted at the site is refined and then used elsewhere. Surrey County Council actually thought, what they've produced gives us sufficient information to be able to grant planning permission. Interestingly, the High Court and the Court of Appeal, when this was challenged by the claimant, Ms Finch, agreed with Surrey County Council. But the persistence of Ms Finch, the appellant, paid off in the end, because in the Supreme Court, and that's the judgment that came out last month, the council decision was found to be unlawful because it failed to take into account the effect of later combustion of the oil. And the question, therefore, is this now what local authorities are required to take into account when they're assessing projects? And that is a big shift, quite specific to the climate change context.
Right. So if you've got a proposal for development where what is developed is something that will produce combustion, that will produce emissions once constructed, once manufactured, do you take into account what it is going to do in order to decide whether or not it should get planning permission in the first place? That's at the heart of the issue. I suppose the question is how many other types of development, because this was specifically a development for doing the very thing, but how many other types of development which require planning permission are going to be required to be assessed in that way?
And I think that is the key question, sort of looking further afield, because I think campaigners won't die wondering. It will be deployed in a variety of contexts to test the limits of what the law following this judgment now requires them to do. I think there's two interesting observations, I think. Firstly, the government's, the new administration's immediate response to this judgment. There was a coal mine in Cumbria that's been at the heart of a lot of public debate in terms of whether whether the UK should be approving new coal mines. That was listed for a hearing a couple of weeks ago. And the government's immediate response was to say, in light of the Finch judgment, we no longer intend to defend this claim. And some of the arguments in Finch were very much at play in the case concerning the Whitehaven coal mine in Cumbria. So I think it's kind of fascinating to first see the government's immediate response to it. But to go back to your question on what other industries might be affected, I think the key question really is around a causal link. So I think Lord Leggett in the Supreme Court made very clear that the oil and gas industry and fossil fuel industry is a very particular type of industry where what you create will inevitably be used, and that can inevitably be measured and particularly properly calculated.
Yes.
Which may not be the case for example, he draws a distinction with the iron and steel industry or your manufacturing parts for vehicles. But I think this will be tested.
What about a new runway at an airport?
Indeed. I think that is possibly going to be the next battleground, and I think it'll be very interesting to see how the court deals with it.
All right. Well, we've mentioned that another aspect of the Climate Change Act is adaptations in light of climate change. That is happening. I spoke to Doug Paulley, a disability rights campaigner, who's taken the government to court over its National Adaptation Programme, which is a plan required under the Climate Change Act 2008. And he started by telling me about one impact of a heart condition he has.
Amongst the kind of neurological impacts of that condition, I struggle greatly with increased temperatures.
Yeah. So
hence in hot weather, or even not in hot weather, I struggle a lot with being too hot, too warm, which is one of the reasons for bringing this case, I guess.
I mean, there's been a lot of hot weather in recent years. I'm thinking back particularly a couple of summers ago to some very, very hot weather. Tell me how you've coped with that. Have you had to deploy particular strategies?
So in my care home, I've bought 4 large air conditioning machines. And in hot weather, I've ended up hibernating in my accommodation in the care home with all the doors shut and with all of the curtains shut. It means that I end up not seeing daylight and that I end up not going out.
So tell me about the judicial review challenge that's currently afoot that you're involved in to do with the National Adaptation Programme. First of all, just explain to listeners, what is the National Adaptation Programme and what basically is your criticism of it legally?
Okay, so there's kind of 2 prongs to the UK's formal response to climate change, and one is about mitigation of climate change itself, which I think is incredibly important. But the other arm is that recognizing that climate change is actually happening and is having an impact on people now is to try and just to some extent buffer against the worst impacts of climate change. And the National Adaptation Plan is required under the Climate Change Act. The government has to write it, I think, every 5 years. And it is a set of actions that the government and state they decide to take to mitigate as much as possible the impacts of climate change on the population. There's three of us taking the case, which is Friends of the Earth.
Yep.
And then a guy whose house very sadly disappeared off the coast due to coastal erosion accelerated by climate change. And then me, and I'm taking it as a disabled person. I'm one of the claimants because it's been shown that whenever there is a significant emergency, and particularly climate change, it disproportionately impacts amongst other groups. Disabled people, it's just inadequate. I mean, whilst you can't truly remove or totally mitigate against the impacts of climate change because it's so massive, we consider that it's just inadequate, the plan that the government came up with. It's been shown that disabled people in care homes, which aren't one and the same, but have a disproportionate risk and are affected disproportionately by climate change, and secondly by any form of disaster or crisis. Such was shown most graphically, to my view, in Katrina back in 2005, when care home residents were left to die in nursing homes, either with their carers having insufficient resources to provide for their safety, or some just being abandoned and dragged out, their corpses stinking after the event, and the same during the recent COVID crisis, when COVID positive people were being discharged into care homes, do not attempt resuscitation orders were being circulated and taken out. And it just became apparent to me and to a lot of other disabled people as a clear example that our lives are often considered not to be as valuable as non-disabled people's lives, or not as worthy of saving, or our quality of lives being more sacrificable than for other people. And climate change is an emergency. And I don't claim to speak for all disabled people, but I think that a lot of disabled people recognize that. And so the concern is that amongst other disadvantaged and dispossessed groups, we are and will be first against the wall. Our quality of lives and our ultimate right to life is considered more expendable, essentially, which puts us at a unique risk.
One thing we haven't talked about, Sahil, yet, but let's come and discuss it now, is the impact of human rights law here. Tell us about the very big, recent, well-publicised decision of the Strasbourg, the European Court of Human Rights, in this area. And I'm particularly interested in whether you feel it's moved matters away from or enables arguments to be not solely focused on process matters and gets into the substance of a policy that a national government might adopt. It's the Verheyen case, I think.
The Verheyen case, which sort of dealt with the actions of the Swiss government. And just if we take a little bit of a step back and just sort of understand what the case was about. The core argument, really, by the claimants in that case was that the Swiss state was not taking sufficient action at a governmental level to tackle climate change, which resulted in a breach of their human rights. And the key argument was around Article 8 of the European Convention. And Article 8, in the face of it, deals with respect for private and family life and a person's home and correspondence. But it's one of the most open-ended of the Convention rights, which covers a whole range of issues that don't have a natural home in other articles. And the key conclusion in that case was that Article 8 must be seen as including a right for individuals to effective protection by the state against the serious adverse consequences of climate change. Now, that's a big statement because it puts the onus on the government to take active measures to put in place a structure that enables climate change to be dealt with at a national level.
Yeah, so-called positive obligations in the language. Usually human rights law is something that stops the state from unjustifiably getting in the way of your human rights, the exercise of your human rights, interfering with your human rights. This is a case where it's been saying that the state needs to, just because of Article 8, positively do certain things. And the question is, what type of thing?
Correct. And I think positive obligations in the case really focused on target setting. Yep. And we'll come on to in a sec to why this is different a little bit from what we have in the UK. But the court essentially said there are two levels of obligations. One is setting targets, which is crucial. And the second is the choice of means to achieve those targets. And the court said for the latter aspect, courts have leeway, have a bit of margin of appreciation to see how they're going to achieve it. But you can't run away from setting the targets, which effectively set the trajectory for what the state wants to achieve. And ultimately, in that case, the Swiss framework was found to have some fairly critical gaps. The interesting thing is that the sole dissent in that case came from the only British judge on the court, Judge Demaika, who felt that expanding the right in such a way could end up being counterproductive because states could just end up getting mired in litigation around every aspect that an individual or groups found didn't help with dealing with climate change. And it sort of reflects some of the UK's orthodoxy around the role of courts and how the development of the law should be cautious and gradual. And it's fair to say that the European Court's judgment was a big leap. And coming to the question of how that might play out in the UK courts, recent cases that I mentioned around the net zero strategy notwithstanding, overall, the UK government has a very clear package of targets, policies and proposals. As Margherita said, they've very much been the front runner in some aspects. So the government will essentially say that we're doing lots and that the judgment focuses on the setting of targets, which we as the UK government are already doing, rather than the choice of means to achieve them. Yep. But there will be interesting contexts in which claimants will look at government decisions and whether, for example, the government is keeping its targets updated in light of emerging science and emerging information around challenges to meeting our net zero targets. And if the government falls short of, for example, updating its targets or updating its strategy, that might still leave a gap for campaigners to bring cases.
So an absence of adequate target setting is potentially in play in an attack on a government's approach, national government's approach to climate change as a matter of human rights law. Let me take a step back from the law in relation to some of these recent cases and just ask, I suppose, more generally about the litigation part of climate change litigation. Margherita, access to justice is something that has its own particular rules or laws in the environmental context in our country. There's also something called the Aarhus Convention, which has made its way into UK law, which alters the position and on the face of it makes it easier for claimants to bring environmental type challenges than from some other types of challenge to government. Just explain what that is and how the rule differs.
So the rule applies to public law challenges in the UK, and what it provides for is that there can be a system of costs capping that reflects the means of those claimants who are bringing cases. So generally, in litigation in this country, if you lose a case, you're liable for the other side's costs. By way of costs capping, you reduce that adverse costs risk, and it means that people like Doug and Kevin can bring litigation without fearing that they'll then be made to pay all of the government's costs when bringing that case. And indeed, we relied on cost capping in this case as well. One interesting point to highlight here, which not many people, I think, are aware of, is that the Aarhus Committee found that the UK was in breach of the Aarhus Convention, which I always mispronounce, because it didn't allow cost capping in the private law claims context. So if I wanted to bring a claim, for instance, against a company for having caused environmental damage, I wouldn't be able to benefit from cost capping because cost capping is not available in the private law space in this country. And it's interesting to see that is arguably a violation of the UK's obligations under the convention. And I think that's an interesting space to watch. Will there be further access to justice in the private law space as well at some point?
So this is the position under international law, in other words, the law that applies to people who sign up to a particular convention, here the Aarhus Convention. And what you're saying is that the adjudicatory body that polices that international law, the decision of that body hasn't been implemented by the UK legislature or the government. If it's got the power to do it, it hasn't extended these special, more generous cost rules in you versus me claims, private law claims.
Exactly.
And Sahil, there's a curiosity about that, isn't there? Some people think we're jolly good for environmental law litigation, that you have a more favourable regime than you do in other contexts. But it does rather put environmental litigation above certain other policy areas where it might be thought, without in any sense disparaging the importance of the environmental law cases, that they are, for the individual or whoever, equally or in some contexts potentially more deserving type of challenges to take the government on with. It's not the case generally. There is some provision in judicial review in state challenges for cost capping, but it's not the position generally that it's as generous as it is under the Aarhus Convention.
Yeah, that's correct. And to put a positive spin on it, I suppose having the more generous cost regime in place does embolden more ambitious sorts of claims. And if you think of the law, particularly in the environmental context, as a way to hold power and decision making to account, it really does open up a whole lot of avenues. But I agree, it does create a hierarchy of importance of claims.
One other issue with access to justice, Sahil, is the question of who can bring a claim. In a you versus me claim, I'm going to be suing because I have suffered myself some sort of loss or damage as a result of something you've done. When it's you or me versus the state is taking some action or is not acting in relation to climate change, the question arises who ought to be able to bring that claim? Aren't more than one person affected by it? And is there a special reason why one person or body should be able to bring it? What are the rules about, can anybody bring a claim? Has it been affected by this recent European Court of Human Rights decision?
So the European decision's particularly interesting because the individual complainants in that case were found to not have standing to bring a complaint because they hadn't been able to demonstrate, as you'd expect in a challenge to a national level policy, an intensity of exposure to the adverse effects of climate change, or that they themselves had a pressing need for protection. Some argue, in a slightly contrived way, accepted the standing of the representative organisations of the Verein, the group, as a representative association, but this was particularly in light of what they termed the special features of climate change, the fact that climate change was a common concern of mankind, and that there was an element of burden share, an intergenerational burden sharing in this context. So I think the court was very clear in that case that extending the right for people to bring claims to organisations would only arise in some very specific contexts. And I think it's going to be interesting to see how the UK courts respond to it, because the UK courts under the Human Rights Act, Section 7, currently a group like the Verein wouldn't have the right to bring a claim because they wouldn't have the standing to challenge it in a domestic court. And the UK courts have always sought to move alongside decisions from Strasbourg, not move ahead, not stay behind, but keep pace with. So I think it will be interesting to see how the UK courts respond to it. There are already very clear standing requirements when it comes to public law challenges, and where this fits in that will be very, very interesting to see. I think ultimately what the court did in Europe is try and find a bit of a balance between ruling out effective challenges by well-established organisations and the risk on the other side, as the government would argue, and indeed as the dissent from the Judge Icke suggested.
All right, well, it may be said that any litigant always needs optimism. I asked Doug Paulley how hopeful he was that litigation such as his could bring about change.
I guess I am more hopeful about, in general, as to the impact if there's any appeal, no matter who wins. And I know from experience that this is quite likely the beginning of the process. I also feel that although the legal is very important, it is but one aspect of bringing a case like this, and that the raising the profile of the issue, both in the public's minds and in official channels, can have unpredictable but also significant impact, sometimes unmeasurable. It is very difficult to know how much down the line the fact that this has been challenged will impact the government's thinking or policymakers' thinking or actions on other issues. I always think back to the Newbury bypass protests in the 1990s. Now, that failed in that the Newbury bypass was built, but also the government's road building programme somehow over the next few years was suddenly very much curtailed. So even if we lose, which I don't think that we should and hope that we don't, even if we lose in court, I think that it will have raised the issue substantially, both in the public's mind and in policy setters' mind, and will also be a win, which is a very glass half full way of looking at things, I guess.
Margherita, if you ask a lawyer whether or not they should litigate or whether or not litigation's a good idea, they'll mostly say yes. But the truth is, isn't it, that in this area, perhaps more so than others, litigation can only be seen, can't it, as one of the tools in the kit of those who seek to bring about change?
Absolutely. And I think, as I was saying earlier, even in the national adaptation case, the challenge we're taking legally is quite technical. It's very much based on compliance with laws, but it can facilitate political engagement, and so it is, if you have perhaps better clarity in terms of what objectives the government sets itself to respond to climate change, then you can have better political engagement by claimants like Doug, Kevin, but also Friends of the Earth, and better engagement with government to see what ambition it seeks to set itself up for when addressing climate change. So certainly there's a whole arsenal of tools in the climate space. Litigation is one of them. It has been recognised by the IPCC, which is the core scientific body that has been largely accepted by governments and courts globally as being the authoritative source of scientific advice on climate change. And they have expressly recognized that litigation has a role in pushing for greater climate action and ambition. So litigation is a tool. It's part of a wide range of tools that can be relied upon, and it's neither more nor less important than those other tools. One example which I think is particularly interesting in the climate and environmental space now, when it comes to the impact that litigation might have on civil society, on public debates, on political developments, is in the corporate space, actually, here in the UK in particular, because there are a string of cases that have been brought, and they reached the two of them reached the Supreme Court. Vedanta and Dukpabi are the names of those two cases, but they've been followed by a large number of other cases that are currently making their way through the lower courts, where action is being taken against UK headquartered companies for their responsibility for environmental, climate harms, human rights violations that are happening abroad, either by way of their subsidiaries or somehow within their supply chains. And what I think those cases are doing is that they're triggering a public debate on corporate social responsibility, and triggering a debate as to how far does that corporate social responsibility stretch? So how far can a parent entity be responsible for everything that happens across their supply chain? And I think that is an interesting area to watch in future.
Sahil, the expression activist lawyer is used often disparagingly, if not always disparagingly, about certain types of lawyer. It's an expression that is applied, I guess, in this area, though not only this area. Is it something that lawyers or the legal community should be worried about? Is it a badge of honour?
I mean, as you say, we've all seen the headlines with activist lawyer front and centre. And I guess the first question is, what does that mean, right? People bring problems to lawyers in all sorts of contexts, and lawyers help them figure out how to fit them into a legal framework and articulate that problem in a legal way. And I think the so-called activist lawyers are part of a system. They just seem to do it in more difficult and high-profile contexts. I think what's sort of quite important to remember is that the system has its checks and balances. So one of the accusations thrown at activist lawyers is that they bring hopeless cases to stop things happening. They're the blockers, not the builders, or that kind of debate. But fundamentally, if it's a hopeless case, the court will throw it out. Yeah. So particularly in judicial review cases, they just will not be given permission. That is, they won't even get to court to make the argument, because the court will say, this case doesn't pass a basic level of arguability.
As it often does. Huge numbers of judicial reviews statistically simply don't get past that initial hurdle.
Exactly. As you say, the statistics show that the courts aren't afraid to do that. So going back to your question about what should lawyers do about it, I mean, we spent quite a lot of time today talking about adaptation. I think lawyers and court systems are going to have to adapt. I think more lawyers are going to have to adapt to the use of law and climate change law as a tool of activism. Whether their client is the activist or the subject of the activism, Margherita just talked about corporate responsibility and pressure on corporates. Whether you're advising an activist or a corporate entity, you are going to have to think in those terms, because ultimately, if you think about the law as not just being words on a page or words in a piece of legislation, but as something to inform social behaviour, to inform public debate, and something that informs policy outcomes, lawyers are using them in more creative ways. So lawyers across the spectrum and courts are going to have to adapt and think about law in that way. So in that sense, we're all activist lawyers, and none of us are activist lawyers. So, yeah, that's my view on it.
Right. Well, activist lawyers or non-activist lawyers, this has been the most informative of discussions. Thank you very much indeed, Sahil Kher and Margherita Cornaglia, for cross-examining with me today.
Thank you very much for having me.
Thanks, Tom.
Thank you. We've reached the end of the podcast, but we'll be back soon, and we'd love to know what you'd like us to examine next. Tell us what you're interested in or concerned about in the world of law by tweeting at CrossExaminePod, or by visiting our website, www.crossexamination.co.uk. Remember to follow us wherever you get your podcasts, and if you've got time, we'd love a positive review on Apple Podcasts. It is the best way to spread the word about cross-examination. Meanwhile, I've been Tom Cross, and until next time, goodbye. Cross-Examination is devised and presented by Tom Cross and produced by Spiritland Productions. The producer is Tayo Popula.